Thank you for attending this presentation on confidentiality and data protection. I'd like to extend a warm welcome to all of you. So just before I start, I'd like to introduce myself. My name is Alison Large and I'm a dento-legal advisor at the DDU. I qualified from Newcastle Dental School in 1999, and after that I spent some time working in various different practices. I was a VT trainer and I then joined the DDU in 2008. I initially started working part-time and I'm now a full-time dento-legal advisor at the DDU. I therefore have first-hand experience in dealing with confidentiality matters that arise in practice and also dealing with confidentiality issues as a dento-legal advisor. The aims and objectives of this presentation are to review the legal, ethical, and contractual duty of confidentiality, to review the key principles of data protection, to understand how to appropriately manage requests for disclosure. For the purpose of continuing professional development, this session is relevant to the GDC's developmental outcome D. I'm going to cover ethical and legal issues and professional behaviours. So first of all, what information in dentistry is considered to be confidential? Well, in essence, it's all the information that you come to know about the patient in the course of your professional relationship with them. Everything that you come to learn about them must therefore be treated as confidential. So, our duty of confidentiality extends to information beyond just that is in the clinical records, includes all correspondence between you and the patient, including emails, telephone conversations, appointment information, and invoices. Remember, anything you may learn about the patient during their attendance to see you is confidential. As a dental professional, you have a legal, ethical, and a contractual duty to maintain confidentiality. Several Acts of Parliament determine how information must be managed. These include common law, the Health and Social Care Act, 2008, the Human Rights Act, 1998, and probably one that you're most familiar with, the Data Protection Act, GDPR, 2018. Confidentiality is absolutely central to that relation of trust, the relationship of trust between you and a patient. Principle 4 of the GDC standards for the dental team, that's this booklet, which you can also access on the GDC's website, clearly sets out what the duty of confidentiality means for dental registrants. Breaching confidentiality could result in a complaint or an investigation by the GDC. Non-registrants of the dental team, for example, reception staff, must also be made aware of their duty to protect confidentiality. As you're aware, there are 4 countries within the UK and all have different regulators. I will run through in turn the regulators appropriate to each of these countries and also their expectations with regards to confidentiality. So, starting first in England, it is the Care Quality Commission that regulates all healthcare services in England. The CQC check that dental practices are managing confidential information in accordance with legislation. For anyone that's been involved in preparing for a CQC inspection, you are no doubt aware of this. Primary care organisations and the NHS Business Services Authority have certain rights to see NHS general dental services records. And this is for the purpose of verification and audit. Dentists should comply with their requests, but this is only subject to patient consent. An NHS regional team looking into a complaint, for example, will normally provide evidence that the patient has given their consent to do so. Some NHS forms, such as the NHS PR form that the patient signs, includes a statement to allow disclosure of records to the relevant NHS authorities. For NHS treatment, the NHS Constitution for England, 2015, explains that the patients have the right to privacy and confidentiality, to have their information kept safe and secure, to be informed about how their information is used, and to request their information is not used beyond their own care and treatment. In Scotland, it's the Patients' Rights Scotland Act 2011, which protects the patient's rights, including their right to confidentiality. And this is when they're using NHS services in Scotland. The Charter of Patients' Rights and Responsibilities includes a section on privacy and confidentiality. This summarises what patients can expect when they share information with the NHS. The Dental Practice Board in Scotland has certain rights to see NHS general dental services records. And just like in England, this is for the purpose of verification and audit. Data protection and confidentiality in private practice is monitored by Health Improvement Scotland. In Northern Ireland, the Regulation and Quality Improvement Authority, RQIA, are responsible for monitoring compliance with data protection legislation. The Minimum Standard for Dental Care and Treatment, 2011, Northern Ireland Department of Health, requires teams to ensure confidentiality is within the current legislation and standard. The Department of Health in Northern Ireland sets out minimum standards for managing confidential information in dental practices. In Wales, it's the Health Inspectorate Wales that require that records are stored safely, maintained securely, retrievable, and disposed of appropriately. There needs to be a policy for the management of records and individuals nominated to be responsible for records management. All staff should be trained and have access to clear procedures to follow. The Welsh Assembly Government have legal powers to require NHS healthcare professionals to provide information, and not complying can result in a fine. So I've covered all the different countries, and in essence, many of those responsibilities are similar. There are also contractual duties to make sure that you are maintaining confidentiality. Within the dental practice, all staff should be aware of their responsibilities to maintain confidentiality and manage data in accordance with the law. All staff should receive training, and it can be helpful if the duty of confidentiality is set out clearly in staff contracts of employment. This is important for non-registrant team members because the practice owner could be held accountable for their actions. Contracts for GDC registrant team members should also include a confidentiality clause. It may be helpful to know that the DDU offers a free associate contract checking service, and this is available both to practice owners and to associate members. To access this, DDU members can simply contact the DDU on our dento-legal helpline. The managing and processing of confidential information needs to comply with the Data Protection Act 2018, and General Data Protection Regulations, GDPR. Local policies must ensure that staff are compliant with the law. GDPR applies to the obtaining, holding, using, and the disclosure of information. This regulation relates to the data of living patients. Do also remember that confidentiality extends beyond death, and I will cover this in a little bit more detail in a later slide. It is the Information Commissioner's Office, ICO, that is the UK's independent body that has been set up to uphold information rights. They also provide useful advice on how to comply. The ICO can investigate breaches of data protection and may issue fines. The GDC standards include guidance on protecting patient confidentiality, particularly on social media, networking and blogging sites, and this is set out in Principle 4.2.3. The increasing use of social media has blurred the boundaries between public and private life, and so the GDC has also produced separate guidance, and this is set out within a document that's called Guidance on Using Social Media. Within this guidance, there is information on using professional social networking websites that aim solely at dental professionals. It's important to ensure that you uphold your duty of confidentiality in any form of communication on the internet. The DDU is aware of instances where dental professionals have found that posts made on what they thought were closed, professional-only sites have later been shared more widely. As a rule of thumb, consider any social media post to be accessible to members of the public, even if it's being posted in one of these closed or professional-only forums. It is possible that even if you were to delete a post, that it may still remain online permanently. Surveillance. At the DDU, we're often asked about using CCTV in practices and in the surgery. It is the ICO that regulates the use of surveillance. So, if surveillance is used in the practice, you must keep a record of your purpose for using the surveillance. This includes how it supports people's needs and what alternatives to surveillance you've considered. Remember, if a camera is situated in the surgery itself, the recording will form part of the patient's clinical record. As it's part of the clinical record, it needs to be stored, retained, and available to be accessed by the patient in the same way that the rest of the patient's record would be managed. Patients must give their explicit consent to a recording being made, and a patient may decline the recording. So it's absolutely essential that you must be able to switch off the recording if it's necessary to do so. GDPR, General Data Protection Regulation. This came into effect on the 25th of May 2018 and replaced the Data Protection Act of 1998. When data is being processed, it must be done so in accordance with the legislation. The General Data Protection Regulations, GDPR, are embedded within the UK Data Protection Act 2018. GDPR includes some principles that were not covered in the previous legislation, and I will look next at the main principles of GDPR in the following slides. GDPR sets out the main responsibilities for all organisations in 6 principles. Data needs to be processed lawfully, fairly, and in a transparent manner. So this means that you need to provide patients with information about the data that is being held at the practice and how it's going to be used. Data should also be collected for specified, explicit, and legitimate purposes. This also means that you can only use the data for the purpose for which it was collected. And in dental practice, that is for the provision of dental care. Data is adequate, relevant, and limited to what is necessary in relation to the purpose for which it's being processed. The data should be accurate and, when necessary, kept up to date. No doubt dentists are used to keeping accurate and up-to-date records, as this is something we would routinely do. Data should be kept in a form which permits identification of data subjects for no longer than is necessary. The NHS published New Records Management Code of Practice on the 5th of August 2021, and this sets out how long NHS records should be retained. We have had members seeking our assistance in circumstances where a patient has attended for a single consultation appointment and then later asked for their record to be deleted. Such a request is unlikely to be granted because dental records need to be retained for specified periods of time. So it would be wise to seek advice if you were to receive such a request. In these circumstances, the information outlined on the practice's data protection policy may be a helpful document to refer to. Data should be processed in a manner that ensures appropriate security. This includes appropriate precautions to prevent against accidental loss, destruction, or damage. GDPR requires organisations to demonstrate that they have appropriate systems in place to protect and manage information. So documented policies are absolutely key. The Data Protection Act draws a distinction between a data controller and a data processor. It's the data controller that must exercise overall control and must be involved in decisions about the release of any data from the practice. They will need to register with the Information Commissioner's Office, the ICO. In dental practices, the data controller is usually the practice principal and all other staff are data processors. However, we are aware that DDU members that are not principals may have been advised to register as data controllers with the ICO. Anybody registered as a data controller will take on a number of responsibilities, and to be able to carry out their role, a data controller would need to control the data in question and be able to take reasonable steps to protect, store, and dispose of the data. We encourage any DDU members any DDU members that are unsure if they need to register as a data controller with the ICO to talk through with us their role within the practice and the patient data that they may hold. GDPR. GDPR also gives rights to patients, and I will run through these. 1, the right to be informed. So contact details of the data controller should be provided, and the patient also has the right to withdraw consent and to complain. 2, the right of access. Information should be provided without delay, and this should ordinarily be given within a month. Fees can't be charged for providing copy records unless it's considered to be manifestly unfounded or excessive. So patients can request copies of their dental records. These should be provided to them swiftly and also without charge. If you considered that the request was manifestly excessive, or there was a lot of copying that was required, this is something that you may want to talk through with your defence organisation. 3, the right of rectification. This is the right to correct data if it's inaccurate or incomplete. 4, the right of erasure, the right to be forgotten. So this is the removal or deletion of personal data when it's no longer necessary. In terms of point 3, if a patient disputes an entry within their clinical records, which they may do if they've received a copy of them, it should not be altered or removed from the record. Instead, simply a further note can be added to make a correction of any error that was previously made. Alternatively, an entry can be added to simply say that the patient disagrees with the content of the previous entry. With regards to point 4, if a patient demands a deletion of their records, contact your defence organisation before you take any action. As I touched upon previously, it's likely that patients' dental records will need to be retained for a period of time. And the time frame for which the records are retained would usually be set out within the practice's local policy. The right to restrict processing. So patients can request that you stop processing data. This means that you can continue to store the data, but that it's not going to be used any further. Point 6 is the right to portability. Individuals can obtain and reuse their data across different services. With regards to dental practices, this means that with the patient's consent to do so, their records can be shared with another dentist that's involved in providing their dental treatment. The right to object. Individuals have the right to object to the data processing. 8, rights related to automated decision-making and profiling. Any form of automated processing to evaluate certain personal aspects of an individual and to analyse and predict things. In general terms, this isn't something that is used in dentistry, but potentially computer systems may allow this already or in the future. The ICO defines a data breach as a security incident that has affected the confidentiality, integrity, or availability of personal data. Some examples of how this may occur in dentistry are, for example, sending personal data to an incorrect recipient. This may be a treatment plan estimate that was put in the post and sent to the wrong patient, for example, or a treatment plan or a treatment appointment being emailed to the wrong patient. Another issue that can sometimes arise in dentistry is when electronic devices containing personal data, including patient photographs, may be lost or stolen. A data breach that is likely to have a significant impact on someone must be reported to the ICO within 72 hours of the organisation becoming aware of the breach. It may be necessary to notify the patient as well, but get advice from your defence organisation before you do this. If you were to decide you don't need to report a breach, you need to be able to justify this decision, and you should document it. There is also a duty to inform the affected individual as soon as possible if there is a high risk that he or she will suffer an adverse effect as a result of the breach That is the loss of data or the disclosure of data. Disclosure. Before disclosing any confidential information, you must be sure that you have the patient's consent to do so. Although it's very unusual, there are some circumstances when you may disclose information without the consent of the patient. Living patients have a right to access confidential information that's held about them. A request for disclosure of records is called a subject access request. Children with capacity can either give or can withhold consent to the release of their information contained within their health records, including their dental records. Normally, children over the age of 16 years are legally assumed to have capacity. Some children under the age of 16 may be assessed as having capacity. In these circumstances, it's still helpful to involve the person with parental responsibility wherever possible. So it's good practice to involve the parents if a child with capacity will allow you to do so. Disclosing children's records. Children are entitled to the same duty of confidentiality as adult patients. There are, however, factors you need to consider. The child's age. Can they consent? Or are they considered competent to consent? Does the person requesting the information have the parental responsibility? And is it in the best interest of the child to disclose the information? A frequent scenario where members have sought advice from the DDU relates to contacts from schools. School staff may on occasion approach dental practices to inquire if a child patient has attended an appointment. This is perhaps because the pupil may have given the attendance of a dental appointment as their reason for being absent from school. This would be considered an inquiry from someone that does not have legal parental responsibility for the child. This information is therefore confidential and should not be shared unless you have the authority from the patient, if they're able to consent to it, or a person with parental responsibility. In the situation described, the decision is quite straightforward because the person asking for the information doesn't hold legal parental responsibility. However, requests to disclose child's records can be very complex and a fraught and difficult area to deal with. And this can be especially complicated if you have to ask who has legal parental responsibility for the child in question. If you're in any doubt, delay the disclosure. Seek advice from your defence organisation before taking any action. Disclosure and the deceased. As I touched upon earlier in this presentation, confidentiality extends beyond death. Rights of access may be granted under Access to Health Records Act 1990, which applies to England, Wales and Scotland, and in Northern Ireland, Access to Health Records Order 1993. We are on occasion contacted by dental practices facing requests from family members in the sad situation where a patient has died. This could be because the patient was part the way through dental treatment. For example, the construction of dentures. The family members may make inquiries about the fees paid for incomplete treatment. Because confidentiality extends beyond death, the family member may not have right to access the information they are requesting from you. The situation may need to be dealt with very sensitively. It may be advisable to discuss this with your defence organisation. We would encourage DDU members to contact us. It is possible that you may need to establish if the family member making the request is an executor or administrator, and if they are actually entitled to the information they are requesting about the deceased patient. There may also be public interest considerations relating to information being requested about deceased patients, and I will cover this in a little bit more detail later on in the presentation. Data Protection Act exceptions. There are indeed some circumstances where a data controller can decline to provide information. Particular care should be taken to ensure that information relating to third parties, that is, anyone mentioned in the record that is not the patient, is not contained within data that is released. Sometimes it may be necessary to redact this information, so you're protecting the confidentiality of those third parties. Again, if you find yourself in this situation, it's sensible to seek advice, particularly if you have any concerns. An example of where redaction may be necessary is where a parent's child have separated and the contact details, for example, the address and telephone number for one of the parents is included within the child's records. Whilst a parent may have right of access to the child's dental records, the information about the other parent may not be something that they are entitled to see. In cases of domestic abuse, for example, revealing the address of one parent to another when they are not allowed to, they're not party to that information or not allowed to know that information, could have potentially serious implications. So any concerns, and please do speak with your defence organisation. So is confidentiality an absolute? Although it is very unusual, there are some circumstances when you may disclose information without having the consent of the patient. An individual's right to confidentiality can be overruled if there is a public interest for this to take place. So what is in the public interests? So this may be child protection issues, management of vulnerable adults, and also for the prevention, detection, or prosecution of a serious crime. Even in circumstances where you're obliged to share information for public interest purposes, consent from the patient should always be sought first. However, if you considered seeking consent for the information would endanger the individual or society, then it may not be necessary to do so. Remember, if you do decide to make a disclosure in the public interest, you should inform the patient that this information has been disclosed. Again, you need to ensure that it's safe and practical for you to provide the patient with this information. When might you breach confidentiality without patient's consent? This may be in circumstances where it's required to by law. This includes the Road Traffic Act, the Terrorism Act, and the legal obligation to report FGM, female genital mutilation, if it is reported to you. This isn't something that a dentist would normally come across in their treatment of patients, but it is possible that this sort of information could be disclosed to you. Other situations are if you're ordered to by a court, if it's approved under a legal process, or if the disclosure can be justified in the public interest. When you're considering about the disclosure in a public interest, this is because there is a risk of serious harm to the patient or others, or it relates to child protection or protection of vulnerable adults. To make a public interest disclosure, you would need to take balanced consideration of the situation. Consider if the benefits of releasing the records outweighs the patient's right to confidentiality. Sometimes the benefit to the individual or society may outweigh the harm. In undertaking this balancing act, you may need to seek advice from a colleague or even your defence organisation. We would encourage DDU members to discuss a disclosure request such as this with us. We would recommend full documentation of the factors considered, the reasons for your decision, and it can be useful in future if any questions were asked about how you came to make the decision to release or not release the information if you have this information as an audit trail. Weeks, months, or even years after the decision was made, you may not necessarily recall how you came to the conclusion that you did. So writing it down at the time can be immensely helpful. Disclosures to police. Whilst being approached by a police officer potentially could be an intimidating situation to find yourself in, consider requests from the police in the same way you would from anybody else that wasn't the patient themselves. The police do not have an automatic right to access confidential information about patients. They have no power to secure dental records without either having a search warrant or a court order. However, there are specific legal provisions which do require you to make a disclosure. For example, for the detection and prevention of terrorism as set out in the Terrorism Act. So, you would no doubt need information to allow you to decide if a disclosure can be made and to find out if the police officer has tried in the first instance to obtain consent from the patient. If they could not obtain consent from the patient themselves, you would wish to know why. Dental members may on occasion be approached by a police officer acting on behalf of the coroner. If this is the case, it is wise to establish that they are acting on behalf of the coroner. The coroner can ask for records to assist in the identification of deceased individuals. Information such as dental chartings and radiographs can normally be disclosed to assist in identifying a deceased patient, and this would be justified as being in the public interest. A coroner or prosecutor fiscal in Scotland is legally obliged to investigate the circumstances surrounding a death and can therefore request dental records. Dental professionals must disclose records if requested to do so by the coroner. But if in any doubt, please contact your defence organisation. It's also sensible to find out what information is needed. If you are making a disclosure in the absence of consent, you should only release the minimum information necessary. For example, if the inquiry is about the patient's contact details, it would be unnecessary to disclose the entirety of the patient's dental records. it would simply be unnecessary to provide the details about the periodontal treatment that patient has recently undergone, or that recently placed porcelain bonded crown on their upper left 7. Before making a disclosure, you need to be able to justify any decisions that you make. Careful documentation, as I mentioned before, is important if disputes arise. It is always best to seek consent if you can. However, it may not be appropriate to seek consent if it puts you, others, or an investigation or prosecution at risk. Consent should not be sought if you've already made the decision to disclose the information in the public interest, but the patient should be informed that the disclosure has been made. So, in summary, with regards to confidentiality, be careful. Most breaches of confidentiality are inadvertent and made by members of the practice entirely in error. One helpful tip is to try not to discuss anything about patients where you may potentially be overheard. If you are asked to disclose information, but you have any doubts, don't disclose the information immediately. Take your time. Check that the person asking for the records has the authority to do so, and document the consent that was given before any records are released. Remember, it is the data controller that must approve the release of records. If there is no consent, seek advice before disclosing. Contact your defence organisation. If you're a DDU member, contact us. Here at the DDU, we are led and staffed by dentists, and we have experience of the real life pressures and challenges you are faced with. Questions. At the DDU, we often get asked questions related to confidentiality, and I thought it may be helpful to run through some of the questions that we quite frequently encounter. A patient's wife has telephoned the practice and is asking about appointments booked for her husband. Can I help her? Now, this is a difficult situation to deal with, particularly if your practice knows the patient well, knows the husband and wife, or knows the members of the family. Also, if reception staff are wanting to try and be helpful, it is tempting to be as much assistance as possible when such a request is made of you. The information about the patient, however, is confidential. The wife is simply not entitled to information about the husband's dental appointments unless the patient himself has specifically given his consent to allow that information to be shared with his wife. So, for the smooth running of the practice, this may be something that you want to look at in your policies and procedures and the systems that you have in place. Is there an opportunity when you're asking patients questions at their routine attendances to make inquiries about who they may give permission to allow amendments or changes or bookings of their appointments? You should then make a record of this, including details specifying who it is that the patient has given their consent to and the limit of the consent. It would relate just to booking and scheduling of appointments, but wouldn't allow any disclosures to be made about the actual clinical care the patient was receiving. It was also sensible to make sure that this isn't a one-off event. When the patient attends the practice, you would want to regularly update the information to make sure that it remains valid. Double check and re-record again the permissions that the patient has given and who they are giving their authority to make these sorts of changes to their appointment. Be aware that people's circumstances do change. So you need to make sure that the permission is absolutely up to date. The patient's wife at the moment may later become an ex-wife, and the patient may no longer want their information to be shared. So keeping things up to date is absolutely essential. Do I need to respond to a complaint that has been made about a family member rather than the patient themselves? So the short answer to this question about complaints being made on behalf of another person is yes. You have a professional obligation to look into and respond to any complaints that are received at the practice. You do, however, need to make sure that you respect patient confidentiality. So firstly, it depends on who the patient is. If they are a patient that's 16 years or older, then you can write the full response to the complaint addressed to the patient themselves. For complaints about patients under the age of 16, unless you've previously decided that they were able to consent to their own dental treatment, then it would normally be entirely appropriate to address the response to the parent or the person that holds legal parental responsibility. At the first stage, within your acknowledgement letter, this is an ideal opportunity to set out how you're dealing with the complaint and why. If you are acknowledging receipt of the complaint to the complainant, the author of the complaint, you can set out how you will be dealing with the matter, but the response will go to the patient themselves because it's going to include information that's confidential to them. Or you may want to address the acknowledgement letter to the patient themselves, explaining that you've received a complaint from somebody else and that you are looking into it. And you are writing to them because they are the patient and you are respecting their confidentiality. In your acknowledgement to the patient, this would be an ideal opportunity to set out to them that although you're writing to them, they're completely entitled to make the decision to share that letter, the content of the letter you've written, with anyone that they may wish to. Whilst you have a duty of confidentiality, the patient's own personal information they can share with whoever they want. Within the acknowledgement, you can also explain to the patient that if they would indeed prefer for somebody else to be dealing with the complaint on their behalf, that you can accommodate this, but you would need the patient's permission to allow you to do so. And often a practice would want to receive in writing from the patient their authority to allow correspondence to be sent to somebody other than themselves. If this isn't addressed in the acknowledgement letter, these same offers to a patient can be set out in the full response, explaining that if they do want the correspondence to be shared with somebody else, or they want any further management of the complaint to be handled by another individual, that they can let the practice know, give their permission, and then the practice can deal with it in that way. Another question that sometimes crops up is the following. A father wants me to explain to him the treatment his 17-year-old son is receiving. Can I provide him with this? So a 17-year-old is at the age at which they can consent for themselves. So you need permission from the patient themselves, the 17-year-old, to share the information with their father. I do appreciate that this can sometimes be a little bit challenging to deal with, especially because 17-year-olds, although they're over the age of consent, aren't yet adults, and their parents may deal with a lot of their appointments and healthcare for them, and particularly if they're involved in paying for treatment, they may feel that they have a right to be involved. However, because the 17-year-old can consent for himself, he has the right to withhold consent for this information to be shared with his father if that is his decision. Generally, it can be really helpful, and if the son were allowed to make the parent aware of the treatment, and this may involve having a discussion with the son about why it might be helpful for you to give information to his father. For the reasons I've said previously, particularly if there's some financial interest, it can sometimes mean that everyone is satisfied if information can be shared more generally. But ultimately, it is the 17-year-old's decision as to whether you provide that information to the parent. It's the DDU's experience more generally that a complaint is less likely to arise if a patient has consented to it, and also if their family members are aware of the treatment they're having and in agreement with the care being provided. Another question that crops up from time to time is the following. The practice have been telephoned by the police and they have asked the receptionist if records of a patient can be released. Am I able to provide these? Whilst disclosures of information without the patient's consent can be made in the public interest, remember, a police officer does not have an automatic right to the records. If you're approached in this way, it's quite common for the request to be made to a member of the practice staff, and often you won't have full details of why the information is being requested. Normally, you will need to find out a little bit more information. Is this a serious crime that is being investigated? Does the police officer have the consent of the patient? If the police officer has the consent of the patient, you simply want to have a copy of that, and that means that you can undertake a straightforward disclosure of records. If the patient's withheld their consent from a police officer, this is something else that you may want to be made aware of, and it may be taken into consideration as part of your balancing act. The police officer may have a warrant or a court order. If they do, you'd certainly want to have sight of that and be aware that that is why they're approaching the practice for the records. You'd also want to find out if they are acting on behalf of the coroner's office. If so, they should be able to put this request in writing to you. You must disclose information to assist the coroner with the identification of a deceased patient. You also need to consider the information provided to you so you can decide whether you have a legal duty to disclose this information. For example, does it relate to the prevention or detection of terrorism? If you need to consider the public interest, remember that balancing act, and the bar is set very high for the detection and prevention of a serious crime. For a matter to be considered a serious crime, usually there would have to be a risk of harm to the public, the patient, or another individual. Sometimes practices may be contacted because the patient has gone missing. An individual going missing may not necessarily be considered a serious crime. In fact, people have the right to go missing, go somewhere, and decide not to tell loved ones, friends, or family. And a missing person inquiry may not therefore reach the level at which you can undertake a breach of patient confidentiality. However, there might be other factors to take into account. Is it a child, or is it a vulnerable person that the police officer is making inquiries about? If it is the case that you do need to disclose the information to the police, think about whether it is the entirety of the record that needs to be disclosed. Normally, you just need to provide the minimal information that's required. So if the police officer is asking for contact details alone, then you don't need to be providing reams and reams of records, photographs, radiographs, and details of clinical care. It can always be helpful to take advice before making a disclosure such as this. The balancing factors to consider in a public interest disclosure are complex, and it can be really helpful to show your workings. That's recording how you came to your decision. Having taken advice from someone else, or having taken advice and input from your defence organisation, can also be a useful thing to record in the records that you did, that will show that you gave very careful consideration before your decision was made. If you find yourself in this sort of situation and you're a DDU member, please do call us. As you can see from this slide, if you need to contact us here at the DDU, we normally answer calls really swiftly. In fact, the majority of them get answered within 20 seconds. We also have a 24-hour advice line, so we can deal with urgent matters that can't wait until our office opens. For the majority of issues, you can call us during our opening hours, and these are between 8 AM to 6 PM, Monday to Friday. And at this time, we have a whole team of dento-legal advisors available so that we can take your call. The DDU is a not-for-profit mutual organisation, and we're here to guide and support our members. As well as providing assistance with complaints and claims, we provide guidance and support you when you're dealing with all sorts of issues that may arise out of your provision of dental care to patients, one of which is confidentiality. And I hope within this presentation, I've illustrated to you how it can be really helpful to give your defence organisation or the DDU a call to chat through any dilemmas that you may face in relation to confidentiality or disclosure. So this brings me to the end of my presentation. I would like to thank you for taking the time to watch this presentation on confidentiality and data protection.